Okay. So we will discuss about banking ombudsman. So banking ombudsman is a statutory authority who are regulating or controlling the complaint system in the banking area. See, suppose if the customer has got some complaint against the bank, he can approach a banking ombudsman. So this has been created uh, by a regulation by the Reserve Bank of India. So in every state we got banking ombudsman. So let's examine what is the role of banking ombudsman, how it's working. Slides are visible, Asha?
Yes, sir.
Yeah. So the Reserve Bank of India has introduced the concept of one nation, one ombudsman through the Integrated Banking Ombudsman Scheme 2021. Prior to 2021, there were three prevalent in the scheme. So Reserve Bank of India has repealed the earlier banking ombudsman schemes, that is 2006. Actually, the initial banking ombudsman scheme was introduced in 2006. Subsequently, two more schemes were introduced. All this has been integrated. Now we got integrated ombudsman scheme 2021. So the new integrated ombudsman scheme 2021 integrates the existing three ombudsman schemes of RBI, namely the banking ombudsman scheme 2006. So initial scheme which was introduced in 2006, that is banking ombudsman scheme 2006. Then the ombudsman scheme for non-banking financial companies 2018. So those companies which are coming under the category of NBFCs, that is non-bank financial companies. To regulate the complaint system of these NBFCs, Reserve Bank has introduced this Ombudsman Scheme for Non-Banking Financial Companies 2018. And subsequently, the Ombudsman Scheme for Digital Transaction 2019 was also introduced to regulate the complaints relating to the digital transactions. Because 2019 onward, there were a lot of transactions are happening digitally in your banking system. To regulate and resolve the complaints under the digital transactions, the Reserve Bank has introduced this Ombudsman Scheme for Digital Transaction 2019. All these schemes were integrated into one banking ombudsman scheme, that is integrated ombudsman scheme in 2021. So you can see the slides. There were three schemes were prevailing prior to 2021. One was banking ombudsman scheme 2006, then ombudsman scheme for digital transactions 2019, and the ombudsman scheme for non-banking financial companies 2018. So all the three schemes were merged into one, and it is integrated. It's called integrated ombudsman scheme 2021. So in terms of integrated ombudsman scheme, any any customer aggrieved by an act or omission of a bank resulting in deficiency in service may file a complaint under the scheme personally or through an authorized representative other than an advocate duly appointed and authorized in writing to represent the complainant in the proceedings before the ombudsman. So who can file a complaint, who can lodge a complaint? Any customer aggrieved by act or omission of the bank. Because of the act of bank, some customer has been aggrieved, he can lodge a complaint with the ombudsman scheme. Or if the bank is not doing anything, doing something which is prescribed by the Reserve Bank, there are in that case also a complaint can lodge a complaint with the ombudsman. This case only a complainant or his authorized agent, authorized representative is only able to lodge the complaint. An advocate is not entitled to lodge a complaint on behalf of his client because it's not a judicial forum, it's only a statutory forum under the scheme of the Reserve Bank of India. No complaint for deficiency in service shall lie under the scheme in the matters involving commercial judgment or commercial decision of a bank. So you cannot challenge a commercial decision of the bank. Suppose you give an application for a housing loan, some other loan. The bank rejected the application due to your credit worthiness or some other parameters supplied by the bank. That case, you cannot challenge it because if you are not eligible as per the bank's prescribed norms, then you don't have a right to lodge a complaint with the ombudsman. So commercial judgment or commercial decision of the bank will not be entertained in the ombudsman scheme. Further, any dispute between a vendor and a bank relating to an outsourcing contract, general grievance against management or executive of bank, a dispute in which action is initiated by the bank in compliance with the orders of a statutory or law enforcing authority, a dispute between an involving employee-employer relationship of a bank, etc., shall not be considered under the ombudsman scheme. So suppose if there is a vendor and bank, some issues are there that cannot be uh, filed under the ombudsman scheme. Suppose the vendors, banks are engaged in a lot of vendors. Suppose they take the case of security personnel. Most of the banks have engaged the vendors for supplying the security guards. So if there is a dispute between the bank and the vendor regarding the deployment, regarding the payment of a security agency's fees, regarding the service conditions of security guards, all this cannot be come under the purview of the ombudsman scheme. This has to be separately take up with the bank, and otherwise you have to file a lot, say, initiate a legal action against the bank under different laws. Or is an outsourcing contract, because banks are now doing a lot of outsourcing contracts. So many activities have been outsourced. So they take the case of cleaning activities, security activities, and even cash replenishing in the ATMs. All these have been outsourced now. So if any dispute is arising out of this contract, you cannot come under you cannot file or say complaint under the banking ombudsman scheme. Or general grievances against the management. Suppose you got any, as a customer, you got any grievance against the policy of the bank, you cannot complain that. Or executive, suppose you got a complaint against a particular person in the bank, for that purpose also you cannot use the ombudsman scheme. Suppose your account has been attached by the bank on the basis of an order from the court, or on the basis of a direction with the police, there also you cannot lodge a complaint with the ombudsman. In nowadays, so many attachments are taking place because of the digital frauds are happening. So many accounts are being attached by the police or by the courts. So if it is attached by the police or court, you cannot lodge a complaint with the ombudsman. So in that event, you have to approach the court, or you have to take up with the concerned authority which has passed an attachment order. Suppose if you have any employer relationship dispute is there, that also cannot be placed before the ombudsman. Suppose an employee has been terminated from the service of a bank, that cannot be considered as a complaint before the ombudsman. Now, the complaint under the scheme shall be admissible under the following conditions. So, you cannot lodge a complaint with the ombudsman unless these conditions are satisfied. Number one, only if a written complaint to the bank was rejected wholly or partly by the bank. Suppose you got a grievance against the bank, you have to first of all lodge a complaint with the bank. If the bank rejects your complaint either fully or wholly, then only you got a right to approach the banking ombudsman. Or the complaint is not satisfied with a reply. Suppose you given a complaint to the bank has given you a reply, but you are not satisfied. That case also you can approach the banking ombudsman. Or the complaint had not received any reply within 30 days after the bank received the complaint. Even if you have received a complaint, you are given a complaint, but it is not replied by the bank within 30 days. Their case also you cannot lodge. You cannot. So if the bank failed to give a reply to you within 30 days, it's failed to give a reply, then within 30 days after that, then thereafter only you can lodge a complaint with the ombudsman. So that means a complaint had not received any reply within 30 days after the bank received the complaint. So you have to wait for 30 days. If you don't receive a reply from the bank within 30 days, then you can lodge a complaint with the ombudsman. So there are three conditions where you can lodge a complaint with the ombudsman. First of all, you have to give a written complaint to the bank, and you'd wait for 30 days whether the bank is giving a reply or not. If the bank gives any reply which is not satisfied by you, then you got a right to lodge a complaint with the ombudsman. Or the reply given of the branches rejected your request or the bank has not accepted your request fully, then or partly, then you got a right to lodge a complaint with the bank ombudsman. So three conditions have to be complained for lodging a complaint with the ombudsman. So the complainant has to make a written complaint to the bank. Before lodging a complaint with the ombudsman, he has to lodge a complaint with the bank, number one. Number two, secondly, the bank may either reject the complaint wholly or partly. The bank may either accept the complaint or reject the complaint wholly or partly. Thirdly, in some cases, the bank may not have given any reply to the complainant within 30 days after receiving the complaint by the bank. Suppose you have not received any complaint, any reply within 30 days, then you got a right to lodge a complaint with the ombudsman. Fourthly, in cases where the complainant has received the reply from the bank, he may lodge the complaint to the ombudsman within 1 year after receiving the reply from the bank. So that means that you got a limitation of 1 year period. Within 1 year only, you have to lodge the complaint with the ombudsman. That means you are given a reply to the, you are given a complaint to the bank. Bank has given you a reply which is not satisfactory to you. Then within the complaint with the ombudsman. Fifthly, if no reply is received from the bank, the complaint has to lodge with the ombudsman within 1 year and 30 days from the date of the complaint. So, in cases where you have not received any reply, that case you can lodge a complaint with the ombudsman within 1 year and 30 days. So, within 1 year, in case if you receive a reply which is not satisfactory, or in case you have not received a reply, then 1 year and 30 days you should lodge a complaint with the ombudsman. The ombudsman, through its award, can direct the bank for specific performance of its obligations and for making payment to the complainant by way of compensation for any loss suffered by the bank's customer. Suppose you have taken a DD draft from the bank. There's a mistake in the draft and the draft lodge a complaint against the bank. Or if you went to the branch, the bank was not open at the right time, you got a right to lodge a complaint. So these are the issues where you have a you can ask for a compensation from the bank. So ombudsman has got a right to direct or to impose a compensation on the bank for the loss suffered by the customer. The award passed shall be lapse and be of no effect unless the complainant furnish a letter of acceptance of the award in full and final settlement of the claim to the bank within a period of 30 days from the date of receipt of the copy of the award. So this is very important. Even if the award is passed by the ombudsman, unless it is accepted by the complainant, the award will not be enforced. That means that suppose the award is passed in your favor, you have to give a letter of acceptance of the award, and if you don't give letter of acceptance within 30 days, the award will not be enforceable. If the bank accepting the award, it may contact the customer and get the acceptance award. Suppose the bank is ready to give the compensation to you, or bank is ready to do whatever is directed by the ombudsman, then bank can contact the customer and get an acceptance of the award. Thereafter, this award can be implemented by the bank. Thereafter, bank may comply with the award within a stipulated period of 30 days and intimate the compliance to the ombudsman within 30 days from the date of receipt of the letter of acceptance from the complainant. So, after receiving the letter of acceptance, within 30 days, bank has to comply with the order. Suppose the customer is not agreeable with the award, he is not satisfied with the award, he or she may prefer an appeal before the appellate authority within 30 days of the date of receipt of the award or rejection of the complaint. So the appellate authority is the deputy governor in Reserve Bank of India. So a customer is not satisfied with the ombudsman award, he can lodge a complaint with the deputy governor of Reserve Bank of India, which is an appellate authority. Likewise, if the bank is agreed with the award, It may also prefer an appeal for the appellate authority. An appeal may be filed by the bank only with the previous sanction of the managing director. This is very important. Suppose the bank want to lodge an appeal against the order of ombudsman, it has to get an approval of the managing director. It is very difficult because to get an approval from the managing director, because in SBI you know that this managing director is sitting in Bombay. If you want to file an appeal, you have to get an approval at various stages, and ultimately it has to be received from the managing director. So it is very difficult to file an appeal against the order of ombudsman, because you have to take a lot of approvals from different people to lodge an appeal before the deputy governor. So normal cases, bank will be compelled to comply with the ombudsman award unless it is approved by the managing director. So it is the responsibility of the bank to accept the complaint, accept the award, or to file an appeal against this order with the permission of the managing director. So most of the cases in 99% cases banks are complying with, because it's very difficult to get an approval from the managing director for lodging an appeal before the deputy governor. So the appellate authority, if it satisfied that the complaint has sufficient reasons for not making the appeal within the time, may allow a further period not exceeding 30 days. So appeal has to be filed within the period of 30 days. And if the deputy governor feels that there is a sufficient reasons for delay in lodging the complaint, he can also accept an appeal after the period of 30 days. So these are the important aspects about banking ombudsman. One of my article is also published in the KLT in the month of September. I shared this article with Varsha, so you can go through the article. All details have been mentioned in the article. Okay, then I think we will switch over to NI Act, because our time is very short. We like to...
Dr. Shamjit, I have two questions.
Yes, sir.
Whether the ombudsman can accept the complaint without the complainant complained with the concerned institution?
No, it cannot be, because first of all, he has to lodge a complaint with the bank, and if it's rejected or if he didn't receive the reply, thereafter only.
No. In some cases recently, about last week only, this ombudsman Bhubaneswar has accepted without referring the complaint to us.
His cause of action arises to lodge.
Whatever similarly,
Yes.
Bangalore ombudsman also accepted the cases. I don't know how they are accepting it. Whatever, and they are calling us. Why you are not giving the reply?
Yes. But I think first of all, the complaint has to be lodged with the bank. That is what the banking scheme says.
Scheme says like that. And another issue is that
Yes.
Whether awarding the award by the ombudsman, whether they will call the bank or NBFC for hearing their views.
Yeah, usually in SBI they are calling, sir.
Because I was I found that they are calling us for hearing our version also. Then only they will award the. In so many cases, in that cases, award was in our favor. They awarded.
Yes. No, usually they will consult us. They will take our opinion also before passing an award.
Okay. Then thank you very much.
Yes, sir.
Sir, I also have a doubt.
Yeah.
So you have earlier mentioned that this complaint shall not lie against the bank when there is an order of court or of police. So suppose a bank account, a specific amount in the bank account is attached by National Payment Corporation of India, whether such an attachment can be challenged before banking ombudsman if the bank is not taking adequate actions or revealing any information regarding the same.
Usually, if there is an attachment by the statutory authorities or police, usually the bank ombudsman will not interfere, because there will be a court order. Usually, there will be a FIR would have been lodged, and on the basis of FIR, the police would direct the bank to freeze the account. Or there will be an order, because now recently we are receiving a lot of complaints, lot of attachment orders from different courts, because the cyber site has opened there, a national cyber cell. So all these complaints have been lodged at the single point, and they're advising the branches, all the branches in India through a single emails. So even if there is an attachment order come from a court of Rajasthan or from the court of Delhi, it is taken up with the cyber cell, and cyber cell will communicate as to attach these accounts. So now the problem is that multiple attachments are happening. Even if previously, we used to get a very rarely we used to get an attachment orders. That is only from the local courts. Now the problem is that all the attachment orders are combined together, and it has been communicated to different branches. So in a single account itself, we got 10-15 attachment orders from different courts. So usually the banking ombudsman will not enter into this area because there is an order, judicial process is on the way. Means there is an order from the judicial proper court, or there is an investigation has been lodged. So in that cases, I think it is beyond the jurisdiction of the ombudsman. I think many cases what the customers are doing, they are going to the High Court, and High Court is issuing directions upon the bank to release this attachment after receiving the security, or directing the concerned police to verify the records and attach. Now the recent judgment is that whatever is amount is attached, you should not have a full freeze of the account. Whatever amount is required to be attached, that only should be kept as attached, while you allow the customer to operate the balance amount. So that is what is happening in many cases. So I don't think ombudsman can understand these cases, because there is a investigation, police investigation is going on. FIR has been launched, criminal system has been put in place. So that cases, I think the chances of interference of ombudsman is been ruled out.
Sir, I understand that. My question was that whether National Payment Corporation of India can order attachment of a bank account, because it is not, it is, even though it is an organization which has come under statute, whether their direction
National
can
payment, on what ground they are issuing the attachment order?
that is unknown, because the bank is not providing sufficient details regarding the same. There is deficiency on the part of bank in revealing the information, and the only information we received is that National Payment Corporation of India has ordered an attachment. So do they have the jurisdiction and power to order such an attachment, and whether that can be challenged before the ombudsman?
No, I don't know whether a National Payment Corporation has got statutory powers to issue an attachment order. That need to be seen. But I think if the bank, which bank, I think you can see. Suppose the branch where the customer is maintaining the account, that branch is supposed to give on what basis the attachment order can come into force. Because even RTA also, somebody is asking about the right to information, the bank is bound to give the details on what basis attachment has been affected and what is the ground. So either the first thing is that you get get details from the branch. On the basis of details, you can write to the National Payment Corporation of India on what grounds it is attached. If they don't have any statutory rights, of course, but at the ombudsman, I think it's very difficult unless there is a statutory power is vested with the National Payment Corporation. Then, of course, I think ombudsman will not interfere it. Otherwise, if an order is not within the jurisdiction, of course, I think it can be considered. But the only thing is the National Payment Corporation, I don't know whether it is coming under jurisdiction or RBI. If it's coming under RBI only, then ombudsman will have a right. Otherwise, I think only banks will come under. Banks can, of course, banks can disclose information, but since the attachment is done by the National Payment Corporation, we need to see on what basis they issued the attachment order, and what is whether they got a right to do it or not. That needs to be seen.
Thank you, sir.
Just to strike a clarity, National Payment Corporation of India comes under, falls as a regulated entity. So RBI is well within the rights to regulate NPCI's operations, and it also comes under the purview of Payment and Settlement Act of 2007. So I think
but only thing is that we have to see whether this on what grounds they issued the attachment.
Correct.
I think they might have taken a court order, then only they have approached the bank.
Yeah. Usually,
Otherwise,
yeah.
otherwise, normally this income tax department, other government revenue department, if any attachment, they can directly ask, or the police. In that case, also court order is required. Otherwise,
Yes.
bank, any specific case is there with the police, and they will say that because of this reason, this account has to be freezed.
Yes.
And
Even-
this income tax and other department, they will say that a specific amount, up to what amount, or GST department, because there are some non-payment of government dues. That is why they are asking the banks to freeze the account or attach a certain amount of money.
Yes. Even ESA corporation, PF, Prawn Fund, all these got a statutory power to make an attachment. So we are receiving, banks receiving a lot of attachment orders from ESA corporations, Prawn Fund organizations, GST, revenue departments. All the departments has got a right to make an attachment. So we have to see, I think there may be something underlying order from the concerned authorities. Thereafter only, I think they will be making it. But anyhow, we have to find out on what grounds the National Payment Corporation has issued attachment. Thereafter only, I think we can take a view whether it can be, or we can lodge a complaint with the ombudsman or not.
Thank you, sir.
Any other?
Bank can ask the concerned authority under which order you are asking us to. Bank can also ask to produce that order.
Yes. I think customer can lodge a complaint with the bank and ask on what grounds the attachment order is coming to force.
Mhm.